Hi there, I'm Matthew Lester from the Rhodes Business School. I'm not wearing a hat today just to cover my bald spot or the gleam that the camera might pick up off it. What we're doing today is taking an imaginary business. I supply hats, thank you very much, and now I want to get on with naming my business. And it doesn't take a genius to realize that the name to a business is quite important. That's similar to a brand name. People get confidence in it, they use it to identify your business, and really an advertising campaign without a name is not really worth having. But what name do you choose for your business? And how is it regulated in South Africa today? So let's start off with the trading entities. And we see that basically in South Africa you can trade as an individual, or what we call a sole proprietor, or in partnership with somebody else. Or you can go out and form a company. Now what is important is that the choice of name for your business, if you are an individual, is up to the common law. It's not regulated by the Companies Act. However, if you want to have a company name, well then that is regulated by the Companies Act, and you've got to take a lot more trouble with what you're doing. So, we have to say, a business name is not necessarily regulated. You've got some freedom there, but watch out for making off another business name. What this means is that you're impersonating another business and trying to trade off their goodwill and their trademarks and brand names, etc. So examples of this would be, for example, if you form Presley's Nightclub, you might hear from the Presley family in America saying we want a royalty for the use of our name. Other big brand names you should watch out for are obviously Coke, Virgin, Gillette, etc. There is some latitude in this, and it doesn't often happen that people are prevented from using a particular trade name unless they are obviously causing trouble. And even then it is up to interpretation in the courts. An ex-student of the Rhodes Business School, Justin Nurse, had an altercation in the Constitutional Court with South African breweries about his name for his t-shirt, Black Labor. And he was fortunate that the Constitutional Court said to SAB, get a sense of humor, we're allowing him to do it. But we don't necessarily want to go there as businesses. We don't want to incur those costs and have all the unhappiness of litigation. We probably can't afford the lawyers anyway. So we want to get it right from the start. So what we do is we say, if we want to register the name of a company, then we have to reserve the name with the Company Commission. And the name must, easy, be in one of South Africa's official languages. Not too difficult on that one. That's an easy one. But the must-nots become a little bit more. They say, right, the name must not be the same of any other company or a name that has been reserved or registered by somebody else. Now, big companies take a lot of trouble about this. They reserve names with the Companies Office to prevent people from making off on their businesses. So we have to be very careful of that one. And then we can't have any of the isms associated with life today. The name basically cannot be offensive. Don't even try and go there and get clever. You're just looking for trouble. The name must, for example, work as follows. If I tried to register the name of Hats for my company, everybody would say there's no way of distinguishing your company from anybody else's company. So you probably wouldn't get it through. If I said these are Rhodes University hats, well then the Companies Office might say, but you're trying to make off on the Rhodes University name. We're not particularly keen on that, so you probably wouldn't get that one either. If I tried Mad Hatters, well, how many businesses are there today that are called Mad Hatters? You won't get that one go through. So I'm going to call myself Rhodes, R-O-A-D-S, Mad Hatters, and yeah, I might get lucky on that. Of course, none of this stops me from registering a company in any other name and then trading my company through another name. I say I am Rhodes Mad Hatters, trading through Lester's Company Proprietary Limited, or any other company name that you have. So you can still carry on using a name even though your name reserved with the Companies Office is of some other form. This gets a little bit complicated and confusing, but it can be done. Now, depending on the nature of the company, we then have to, after the name, give an indication as to whether it is a public or private company. So a private company has the initials Pty Ltd behind it, and a public company has Ltd behind it. That's simple enough. And then, if the memorandum of incorporation or the constitutional documents of the company has so-called restrictive provisions in it, that's not very common, then the name of the company has to be followed by the initials RF, which means that the company is ring-fenced against doing certain things or other things. That's basically a public health warning. The name of the company is then reserved with the Companies Commission upon payment of a fee and the submission of documentation. Notice at this stage you haven't even got a company. The first step to getting a company is to get a name for a company. This is a process a lot of people try and circumvent. I advise people, make sure you've got a name before you even start trying to put in your paperwork for the rest of the company. You'll save yourself a lot of time. Now we get to, let's do it all ourselves. We get onto the website of the Companies and Intellectual Property Commission. There it is on cipc.co.za. There's the opening page on the internet. And we start trying to do all of this ourselves. And you'll need to put a hat on for that, because otherwise you're going to pull all your hair out. This is stuff that you've got to work with every day to get good at it. And that's why you'll probably be a hell of a lot better off if you just pay a company secretary to do it on your behalf. So once we found a name that's acceptable to the Commission, we reserve the name, the company can then be registered. And this is achieved with a lot of other frustration, because this is where we get into the red tape of running a company. So again, the best thing, as I have advised before, is for the company to get a secretarial specialist to form your company for you and lodge all the documents. Pay a little bit of money, it will save you an awful lot of time. A company is formed by completing and filing a notice of incorporation together with a memorandum of incorporation, an MOI. Now, an MOI is basically a very lardy acronym for the rules to running the company. Now, there are various ways of doing this, and it can get complicated or not so complicated. The MOI is the constitution of the company, and it governs the nature of the company's activities and how it's going to run. Now, once the Commission has received and approved a notice of incorporation, it's going to assign a unique company registration number to the company and issue a registration certificate. Thereafter, all that registration certificate number has got to appear on all correspondence of the company in the future. Then, in addition to the MOI, the company can make its own rules as to how it operates. Basically, what happens is companies are normally formed on a standard template, and that's more or less the way to go. But some business transactions want it to be a little bit more complicated, so they start writing rules, and the rules also have to be filed with the Commission together with any subsequent changes in the rules. The company can also have a shareholders agreement, which regulates how the different shareholders have got to behave in relation to each other. Well, if there are multiple shareholders, that might be necessary. And then the MOI and rules are then binding on everybody. That's between the company and its shareholders, or between the company and each director or officer of the company, which is responsible for the administration of the company, or any other person who is serving the company as a member of any committee of the board of directors. And so we continue. The regulations of the Companies Act give standard templates for rules and MOIs, etc. It's suggested that you adopt those. Alternatively, you can modify them. But please don't try and do that yourself. That's where you're going to again need the help of a company secretary or properly a lawyer to do that. If the MOI is modified, a unique MOI is then drafted, lodged with the Companies Commission, but any rule is not allowed to the extent that it may exceed the provisions of the Companies Act. So you can never ride roughshod over the Companies Act. Then, The MOI can also address matters which are not addressed in a standard template. It can also impose more onerous requirements on shareholders and directors, for example. And then some people want unalterable provisions, which can never be altered in the MOI once it's been lodged. MOI may also have restrictive provisions that restrict the company and its directors in the way that it operates. Where this is the case, the notice of incorporation must include a prominent statement drawing attention to these restrictive provisions. That's the health warning that goes out to the public to tell them, watch out, there's special conditions relating to this company. The name would, of course, then bring in the initials RF afterwards to show that it is ring-fenced. This is basically to keep the public informed that there are special rules relating to this company. Any amendment to the MOI is going to also have to be lodged with the Commission, and an MOI may only be altered in terms of a court order, or else there will have to be a special resolution passed by the shareholders. We'll go into what special resolutions entail at a later stage. The board can make changes to the authorized and unissued share capital of the company unless there is a restrictive provision in the MOI. However, if they do so, such changes have to be lodged with a notice of amendment to the MOI, which gives out all the details of this to the company's office. But once you've got a company, that's when the problems start. So then you're going to have a registered office somewhere in South Africa. If the company's books and records are kept at another destination, then the company's office must be informed accordingly. And now we start. We have company records are in various regulations and legislation. They must be kept in convertible or electronic format or in paper for a period of 7 years, sometimes even longer. Now look at all the records. You've got to have copies of the MOI. You've got to have copies of the rules. You've got to have a record of past and present directors, going back at least 7 years to the resignation of past directors. Then you've got to have copies of all reports presented at annual general meetings, and annual financial statements and accounting records, and notices and minutes of shareholders' meetings and resolutions that may have been passed at those meetings. And we have to have documents relating to all securities and to any resolutions that might be applicable. And then written communications set out to the holders of company securities, minutes of meetings and board committee meetings, etc., a securities register, details of the company's secretary and auditor. And we're not finished yet, not by a long way. We have to have a financial year end. We have to have accurate books and sets of records, and we are going to have offences which come into play if the books and records are in any way falsified. So there are massive provisions as to how you run your company. The accounting records have got to show assets and liabilities, records of loans, detailed records of liabilities. They've got to go into registers of property, registers of expenditure, detailed statements of account of any financial institution where you may have a bank account. And so it carries on. Every year there will have to be annual financial statements. Some companies are required to be audited, others are not. Certain owner-managed businesses, for example, may not require an audit. But that doesn't mean they don't have to keep accounting records and will need the assistance of an accountant. And then there is certain minimum information which must be contained in the financial statements every year. Then you're going to have to complete annual returns. And if a company is required to have its financial statements audited, you're going to have to lodge them with the company's commission. And then a company that is not required to have its financial statements audited, well, they might not want to put their financial statements into the company's office every year. And so it carries on. The Commission obviously monitors this on an ongoing basis and may even change such regulations. After you've done all of this, one looks at the Companies Act being the minimum requirement for the retention of records and red tape. We will see in the course of all these lectures that there are various other records that have to be kept for example, for income tax, value-added tax, for your labour law requirements, and BEE requirements, etc. So what we're getting to at the end of the day is that if you want to form a company, you are going to activate massive red tape requirements far beyond just choosing a name for the company and getting it registered and get going. We'll deal with all of those in future lectures in this series. I'm Matthew Rest at the Rhodes Business School. Thank you for your attention.